Hi, once again, I'm Michael Redden. I'm an estate planning attorney here in Minnesota, and I'm going to cover another topic that comes up pretty frequently that people want to know things about, and that's living probate. I know most people think that probate's just for when you die, but what you might not know is if you can't take care of yourself, if you need a guardian, if you need a conservator, that still goes to probate court. That is living probate. And a guardian is someone who's appointed to make the medical and basically any non-financial decision that needs to be made for someone who can't take care of themselves. Maybe they are in the hospital, maybe they've started to get dementia, or maybe they're just not able to take care of themselves and can't voice their opinion. And so a guardian needs to be made that way. And there's also someone that can be appointed that's called a conservator, and they're supposed to conserve this person's assets for their benefit, to keep them from being taken advantage of. This is the person that's going to make those financial decisions that are so very important and that the person can't make for themselves because maybe they're just not able to do so anymore. So this is living probate, and one of the big deals with it is that it is not a private thing. Okay, living probate is different. It's where I've got a court record down there, and that conservator is going to take an inventory of all the things I own, all my income from wherever it's going, and they're going to have to report to the court every year and say, hey, look, this is every cent that came in and every cent that came out. The court's interested in making sure they weren't taken advantage of, so it's not private. Everything you own is out there. Most people can just walk down to the courthouse and say, I want to see this file, and get to see most things. They won't see your social security number. They won't get to see your bank account numbers and things like that, but they'll get to see what you own and where it's being spent. And a lot of decisions that the guardian wants to make sometimes will have to also go in front of the court. And it's disruptive. No one wants to say, I have to declare this loved one incompetent, because it's called incompetent when they're declared that way. And people just don't kind of like that. We don't want to do it. It's painful. It's not good for families. But estate planning can kind of prevent this process. There's a couple of things you can do. One, you can make a durable power of attorney, which basically lets someone take care of your financial affairs, even if you're incapacitated. If you can't make those decisions, this person can go to the bank. They can do all these things, take charge of it. So there's no reason really to bring a conservator in most times, unless you don't cooperate. Because sometimes we can be high functioning, we don't realize that we can't make our decisions for ourselves, and we can call the bank and say, don't listen to that power of attorney. And if we want to cover our medical decisions and maybe not have a guardian a lot of times, then we can make an advanced healthcare directive. Just a fancy word for saying it's a document that says, hey, I want my spouse, Uncle Bob, or whoever to make my medical decisions for me if I can't. And that's just kind of how that works. Now, if I don't cooperate, I still will have to be declared incompetent and have some things go. Another thing that can be done for this is a revocable living trust. Anything inside the trust you don't own anymore. The trustee's there. The trustee gets to make these decisions to control your money. And when you become incapacitated, a different trustee will step in, and then that person can take care of your things. And trusts are private. There's almost no reason ever that a court needs to invade the trust and pull things into that public file unless the trustee was stealing the funds or misusing them, and that doesn't happen that often. Even if you were to become just ornery and didn't want to cooperate and got declared incompetent, the stuff that's in the trust doesn't become a part of that conservatorship file. It doesn't get to put out there for the whole world to see and second guess and look, and it doesn't really have as much expenses because most conservators and things are going to need an attorney to fill out these court forms and things every year. For a lot of these revocable living trusts, there's a lot less document keeping that needs to be done and things like that, and one of your family members or someone that you chose will really be able to take care of that. And so you really need to know about living probate too. Planning for living probate or for incapacity planning should be a big part of your estate. And even if you're young, especially if you're young, because we never expect this to happen to us. If something happens when we're young, we could need help for 20, 30 years, whereas when we're older, maybe that helps for 3 years, 4 years, 5 years. So if you're young especially, you need to have some of these things. It's something that everyone should have, and at least have that power of attorney and advanced health care directive. And if you want to know about avoiding living probate or anything like that, contact an estate planning attorney, or you can contact me, and I'll gladly help you understand those kinds of things.